Should you sell or rent inherited property? Sell inherited property if you need cash, want a clean division among heirs, live far away, or the house needs work. Rent it only if the property is rentable, the local market is strong, and the net income still works after real expenses. The right decision comes down to 5 things: who has authority, how much cash the family needs, the property's condition, the local rental market, and the tax consequences of selling now versus renting first. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes Citi Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell or rent inherited property, speak with a CPA, and when probate or trust administration is involved, an estate or probate attorney. When does selling make more sense than renting? Selling makes more sense than renting when the heirs need liquidity, multiple beneficiaries need to divide the value, the property needs major repairs, or no one wants the ongoing responsibilities of being a landlord. Selling turns the home into one lump sum. That can help the family pay debts, distribute proceeds, invest elsewhere, or move on without future fights over tenants, vacancy, repairs, insurance, and maintenance. If the home needs a roof, electrical work, plumbing, HVAC, or other deferred maintenance, renting may require serious cash before the first tenant ever moves in. If your first reaction is, who is going to handle all this? Selling may be the cleaner path. When does renting make more sense than selling? Renting makes more sense when the home is already in rentable condition, the local market supports stable occupancy, the heirs do not need the money immediately, and the family wants long-term income instead of one sale payout. Renting can also be a temporary bridge when the family is not emotionally ready to sell, but it only works if the numbers work after taxes, insurance, maintenance, vacancy, property management, HOA dues if applicable, and any remaining mortgage payment. The question is not just, can this house rent? The better question is, does the net rent justify the risk, time, and concentration in one inherited asset? Who has authority to sell or rent an inherited home? Authority belongs to the person or people with legal power over title, an executor or personal representative with probate authority, a successor trustee if the trust owns the property and grants that power, or the titled co-owners after distribution. Can an executor rent an inherited house before probate is finished? Sometimes, but only if the executor or personal representative has authority under state law, court orders, and the estate documents. In many probate matters, that authority is shown through letters testamentary or letters of administration. Trust authority only helps if the property is actually titled in the trust. The successor trustee's power to sell or lease comes from the trust document and state law, not just from being named as trustee. If multiple heirs already own the property, confirm who must agree before anyone signs a listing agreement, lease, repair contract, or sale contract. Authority problems can slow everything down, so solve them before debating rent versus sale. How do taxes affect selling versus renting inherited property? Taxes affect the sell or rent decision because a quick sale may use the inherited property's stepped-up basis, while renting creates taxable rental income, depreciation records, and possible depreciation recapture when you sell later. Under IRC Section 1014, inherited property generally receives a stepped-up basis to fair market value at death, or to the estate tax value if a permitted alternate valuation applies. If the property sells soon after death near that value, federal capital gain may be small or even zero. Do you pay capital gains tax when you sell inherited property? Often there is little or no federal capital gain if the home sells near its stepped-up basis, but post-death appreciation, selling costs, depreciation, state taxes, and the timing of the sale can change the result. If you rent first and sell later, keep cleaner records. Rental income is taxable, and most individual landlords report rental real estate income and expenses on Schedule E. Sale reporting may also involve Schedule D and Form 4797 depending on the facts. As of 2026, depreciation allowed or allowable during the rental period may later be taxed as unrecaptured Section 1250 gain at up to 25%, and some sellers may also face the 3.8% net investment income tax. That is why a CPA should be involved before the family decides to rent. How should multiple heirs or out-of-state heirs decide? With multiple heirs or a long-distance property, selling is usually simpler unless the heirs have a written agreement, reliable local management, and enough net rent to justify holding the home. What if siblings disagree about selling or renting inherited property? Do not rely on a handshake. Put the agreement in writing, decide who pays expenses, define who approves repairs, and talk with an attorney before one heir starts managing the property. If co-owners cannot agree, an attorney may discuss a partition action, but that is usually a last resort legal path, not the first step. Long-distance landlording adds cost and risk. Many property managers charge around 8% to 12% of monthly rent, but heirs should also ask about leasing fees, renewal fees, maintenance markups, setup fees, inspection charges, and minimum monthly fees. How do you calculate whether renting is worth it? Renting is worth it only if realistic rent minus property taxes, landlord insurance, maintenance, vacancy, property management, HOA dues, mortgage payments, and reserves leaves enough net income to justify the risk. How do you calculate net rent on inherited property? Start with realistic market rent, then subtract the recurring costs and a repair reserve. Do not forget first-year costs to make the home legally rentable, including safety repairs, code items, smoke detectors, carbon monoxide detectors, or local rental registration where required. Before deciding, get a defensible date of death appraisal for tax basis if needed. A broker price opinion or comparative market analysis can help with pricing, but a formal appraisal is usually stronger for tax documentation. What should you do next if you decide to sell? Before selling, confirm authority, establish value, clear up probate, trust, title, mortgage, insurance, and multi-heir issues, and then choose a broker who understands inherited property sales. Inherited Property Match can connect you with a vetted broker experienced with probate, trust, multi-heir, out-of-state, and as is inherited property transactions. The match is free. If you inherited property and selling looks like the cleaner path, start by confirming who can sign, what the home is worth, and what legal or title issues need to be resolved before the property is listed.